And one of the other issues, obviously, that keeps on coming up, and again it was addressed today, is the issue of recognition of the Charter of Fundamental Rights by the Lisbon Treaty as having an equal value as the two treaties it amends. But the fact that even though it safeguards the right to strike, the right to collective bargaining, the fact that the European Court of Justice, which will be responsible in the future if the Lisbon Treaty is passed, as interpreting the Charter of Fundamental Rights, has set legal precedent, and these precedents will actually have to be recognised in future rulings, that immigrants from cheap labour countries can be brought into more developed European countries to significantly undercut the standard wage agreements in the countries they come into, such as the Laval case and the Viking case. Now, people have said, including myself, that this doesn't necessarily have to be an issue and it can be addressed in legislation. But if this has been set as a precedent, then does this not mean that this is where the European Court of Justice will have to look for guidance in the future?
Well, first of all, it's not a precedent if the Lisbon Treaty is ratified, because remember that those decisions were taken by the European Court of Justice based on existing European law and the existing European treaties. The existing European treaties do not have the Charter of Fundamental Rights attached to them, which contains the right to collective bargaining. If the European Court of Justice were to look at the Laval case again, it's quite possible, based on the Lisbon Treaty, if they were to look at it after the ratification of the Lisbon Treaty, that they might make a different decision. In any event, what the Lisbon Treaty enables Europe to do, and indeed member states of the European Union to do, will be to legislate in a way which would deal effectively with the Laval case. I think the point that has to be remembered about Laval is that that decision was made based on the existing treaties. Those treaties, if Lisbon is ratified, will be amended, will include the Charter of Fundamental Rights, which will include a right in the treaties of Europe, in the European treaties for the first time, a right to collective bargaining and a right to strike.
Okay, it had been stated basically that if it was to interrupt with the organisation of the common market, which is what the judges said in these verdicts of those judgments, if it interrupted with the organisation of the common market, then those fundamental rights could actually be restricted to a certain degree. Now you're saying that without the Charter of Fundamental Rights being recognised, but they did actually, and they have up until now, actually used the Charter of Fundamental Rights as a reference, not a legal reference, but they have looked at it in a lot of cases.
Yes, but the problem up to now is that it has been the European Court of Human Rights in Strasbourg which has been mainly responsible for the interpretation and for the enforcement of the Convention on Human Rights on which the Charter is based. The inclusion of the Charter of Fundamental Rights in the European treaties will give the European Court of Justice the right now to interpret the Charter in a way that it didn't have previously. And secondly, it now means that future European law and future European legislation will have to take into account what's in the Charter of Fundamental Rights, including, for example, the right to collective bargaining and the right to strike. So what can happen now on Laval is that the European legislature, or indeed national parliaments, if Lisbon is ratified, will be enabled to pass legislation which will deal with the Laval case. We must remember that the Laval judgment was based on the pre-Lisbon treaties. They quite possibly would make an entirely different decision if Lisbon had been ratified before that judgment had been made.
And now another one of the issues that was raised in the debate that you just, the information that you were just passing out, was relating to the recent cases in the European Court of Justice, such as the Laval and Viking cases, where immigrant workers from cheaper labour EU member states were brought into more developed states, in the case of Laval case Sweden, and Swedish strikers who tried to block them using industrial action were found to be acting illegally by the European Court of Justice. Now some of the supporters of the Lisbon Treaty say that this was allowed to happen because the Charter of Fundamental Rights is not legally binding, was not legally binding at the time of those verdicts, but after the Lisbon Treaty, with it becoming a legally binding document, it will in fact save workers, save sort of union rights and such actions in the future from such decisions. Would you agree with this?
They haven't read the verdict, if they say so, because what the court does is exactly to take the Charter of Fundamental Rights, the sentence, right to strike, and then they take this fundamental principle from the Charter and put it at the same table as the free movement of services, and then the court judges on these two fundamental principles and say that the right to services to be sold for free across the borders is a little more important than the right to strike. So they deem it illegal to make a trade union dispute for higher salaries if the salary paid is in accordance with the national law. If you have a national law with a minimum rate, as you have in Ireland, €8.65 an hour, then it's legal for trade unions to make trade union disputes to have the €8.65, and it becomes illegal if they want €9 or more. The minimum salary they can require, but they cannot require something more. This is the result from the verdicts, 11th and 18th of December in the Viking and the Laval case. And then the court continued the same path with the so-called Rufford case from the 3rd of April this year. There was a building company building in a German state. The Polish workers paid the half salary of what German workers should have. And there it was deemed illegal to require from a building company that they should stick to normal salaries in the contract. It was deemed illegal. And this is far more important because we have an international convention in the ILO allowing public authorities to set such clauses in building contracts, in tenders, that all those who have a bid shall respect the general normal salary. It's a clause, an international respected clause. This clause was outlawed by the European Court in Luxembourg. So it's not possible, for instance, for the Irish state to say if a foreign company would come here and set up a service of education, selling English lessons, for instance, that they should then pay the normal Irish salary. No, they can come here and pay the workers or the teachers €8.65 an hour, and that's it. And it's illegal to act for more.
So national wage agreements are completely under threat from this sort of precedent that has been set, and you don't see the Charter of Fundamental Rights being included in the Lisbon Treaty as going to make any difference?
The opposite. They have already used the Charter of Fundamental Rights and judged on that. They have done that several times. But here explicitly, there's a right to strike, and they say this right is not as important as the right to sell services for free across the frontiers. So we lost that battle. I tried already in the convention. I tried to make it clear with proposing a social clause together with the Danish TUC. We elaborated a social clause to insert in the treaties to avoid those situations which have now appeared, but we failed in the convention, and now we are in a mess. And this is much more serious than you can dream about. From 2010, we'll have the Service Directive. This is secondary legislation covering also education. From 2010, there will be complete free enterprise in setting up companies providing education, and it will be impossible to require them to pay a normal teacher's salary. They can take teachers from everywhere for €8.65 an hour. That's the only thing you can require.